I would like to do is I would like to have in the order of appearance on the panel today, first we'll go to John McGarren, then Joe Simpson, then Steve Casey. So John McGarren, what are your some key thoughts you would like to leave the audience with?
I think I want to emphasize that the use of experts in toxic tort, the use or, in the case of a defendant, the attack against the plaintiff's experts is become a key component of this type of litigation. My observation and experience has been that the quality of the experts have increased greatly from 5-10 years ago that are being used by plaintiffs in these types of cases, and the level of sophistication and the financing of the experts' efforts has increased dramatically. So as Steve had mentioned, these cases can become very expensive to defend, and really focusing in on the expert component of these cases and putting the right resources into it is absolutely critical. Thank you.
Thank you, John. Some key takeaways now from Joe Simpson. Joe.
Yes, thank you. With regard to class certification, we spoke earlier about this. While the trend is that both federal and state courts seem to be becoming increasingly hostile to certifying environmental nuisance cases as class actions, clearly the case law still goes both ways on this. And if you're on the plaintiff side and you feel you have a valid class, you don't want to give up on the idea of pursuing that. Likewise, if you're on the defense side, it's certainly an issue that you have a really solid chance at defeating class certification, but it's not a no-brainer, and the cases clearly go both ways, as evidenced by the Freeman case out of Iowa that we discussed earlier. With regard to some of these other issues and defenses that we spoke of, preemption, permitted activity, and statute of limitations, I would just encourage any of you who become involved in environmental nuisance litigation to take a really deep dive on those issues. You may find that you have a defense that you would not expect to have based on the way the pleadings are framed and the testimony as it comes in during the discovery process. So there is lots of room for good lawyering here in these types of cases, so I would encourage you to dig in where you feel it's appropriate.
Thank you, Joe Simpson. And now, Steve Casey, would you like to take a minute or two to give us what you think the key takeaways for this event are?
Sure thing. Two points I think I'd make. First, I can't overemphasize to you the importance of conducting discovery with respect to the plaintiffs, or I suppose defendants for that matter, social media outlets. As I mentioned during my remarks earlier, particularly the younger generation today, and for me that includes a lot of folks. It's all relative, you know. They tend to self-surveil. They love to post video, photographs, comments about themselves to the world. I mean, sometimes they think they're just exposing it to their friends, with of course an expanded definition of the word friend than from what we had when I was their age. But they're really broadcasting an awful lot about their lives to the world. I continue to marvel at how many folks will send out a message to the world on a multitude of social media outlets saying, here's where which contains information about their home address and the fact that they are on vacation now in some Caribbean clime and how long they're going to be gone. I've always wondered how many folks who make a living robbing folks use that to their advantage. Same thing is true about plaintiffs. So we've had cases where we've done directed discovery towards plaintiffs to try to get their social media information, and a plaintiff's counsel seemed just shocked that we would even think about doing that, and realized pretty quickly that there's a lot of damaging information that they're clients themselves have posted on social media. The second point I would make is consistent with what John McGarren said just a minute ago about expert testimony. When the Daubert case first came out, and when courts first began realizing the need to put some limitations on expert testimony, there was a real reluctance, at least in my part of the country, for judges to do that. They didn't want to do it because they really like everything to go to the jury, and they didn't feel like they were qualified to do it. But with the toxic tort cases involving such complex science these days, we're seeing judges realize, I think by force, they realize that it doesn't make any sense to let just anybody testify about these very complex scientific issues, and they're becoming more serious about their gatekeeper responsibilities with the case of Daubert and other devices that allow them to hone down and try to make sure that expert witnesses who give testimony in their courtrooms are actually qualified to do that, and that their theory of liability makes some kind of sense, and not just letting anybody come and say anything they want to from their witness stands. That's been helpful on the defense side. I think it's helpful on the plaintiff side as well. It's helpful for our entire jury system and system of justice in this country, and I think we're seeing that.